Sargent. Looks like we're missing somebody. Do you know anything?
I don't believe the appellant has counsel at this time.
Oh, is that right?
Mr. Dorwart has advised our clerk that he is not going to be present and that he does not represent the appellant.
Meaning he's withdrawn as counsel?
There is a bit of history with that. Apparently, Anthony Lagos was co-counsel with him and he had withdrawn. It was Mr. Dorwart's understanding that he was withdrawn on behalf of both Mr. Lagos and Dorwart. So it is Mr. Dorwart's understanding that he does not represent the appellant and he will not be present.
Okay. Well, yeah, come on up, Mr. Wagner, because I have raised a separate jurisdictional concern here, so I at least want to address that this morning.
Yes.
So, obviously, in looking through this record, we had a concern with respect to a jurisdictional issue. Are you prepared to make remarks in that regard? If you would, please.
May it please the court, I'm Jeff Wagner, the attorney for the appellee, and I reviewed the court's order regarding the jurisdictional issue. In looking at the statute allows the trial court, sorry, I'm blind, that the trial court may determine any controversy between the parties before it if it can be done without prejudice to the rights of others. The determination made here by the trial court is, and granted the order is not a model of clarity, basically in my opinion is that there was no partnership, and because the court determined that there was no partnership, it could determine it without prejudice to the rights of my client's wife, the way the court did it here. Now, if this court were to reverse that, then I think obviously she would have to come in. If the court finds that there's a partnership and we need to go forward with the dissolution and the accounting, then I think she would have to be brought in. But as it stands now, the way the trial court determined that there's no prejudice to her rights, and I don't think she's a necessary party or an indispensable party, given the way the case has been decided at this time.
Okay, so if prior to the time it was decided, because there's a possibility that the court could find there was a partnership, under those circumstances, she would have been an indispensable party. Your position is because the court went forward and didn't, it doesn't matter, no harm, no foul.
That would be correct. The plaintiff made no effort to bring her in as a necessary party. Mm-hmm. It was my position that there was no partnership here and she was not necessary or indispensable because there simply was never a partnership. Mm-hmm. And that is how the court decided it, so there's no prejudice to her rights.
And you take the position the court decided there was no partnership, but it seems like you said, it's not a model of clarity. It seemed to suggest there is a partnership, but that it wasn't breached.
The court does not, well, that's their contention, that there was a partnership, but the agreement wasn't breached. The order doesn't come right out and say we find there was no partnership or we find there was a partnership. The closest that the court can find is the quote that the evidence offered is insufficient for this court to find that the defendant breached any of the terms of the partnership agreement as it existed between the parties.
So, yeah, I don't know what that means, I guess.
I don't know what it means either,
but
I would point out that because the complaint was dismissed in its entirety, it must mean that there was a finding that there was no partnership.
Appellant filed the brief here, so if we were to look at it and say that we do think that there was a partnership, now you do have an indispensable party issue, right?
I would agree with that.
Okay. Okay. Anybody else?
Do you have any just other argument you wish to make on that point, Mr.
On the partnership point?
Yes.
I think Mr. Bagley very much wants there to be a partnership. I think when you look at Keytronics in those factors, basically Mr. Bagley did little, if anything, here, as I think my client testified to at trial, some sort of minutia of involvement here. He had no skin in the game. My client wanted him to have skin in the game. The properties were in fact purchased by my client and his wife, who had all the risk of loss, had made all the contribution to the purchase of the properties, were the co-owners of the properties. There was no control sharing between my client and Mr. Bagley, and there was no ever any profit sharing between my client and Mr. Bagley. To the extent there was any profit, I don't know that there was. But.
Well, address for me, if you would, I mean, when you look at that record, that email jumps out at you. The email from your client to Mr. Bagley saying, I never disputed that there was a partnership or 50-50 or words to that effect. It's made it seem more as if the contention was, look, I don't agree with the divide here. You're not giving me enough as it relates to the expenses that I put in, or the time that I put in. They were fighting over the distribution, but not over the issue of whether there was in fact a partnership. What would you say in that regard?
I think that was a hope that they would reach an agreement, that they would come to some agreement regarding there being a partnership. Even Mr. Bagley's own testimony throughout this is that that was never, they never agreed essentially to the terms. And they kept wanting to reduce it to a written partnership agreement because they could not agree to the terms. I think my client ultimately hoped they would agree to the terms, but they could not. And ultimately, my client was the one going forward with all the skin in the game. So.
Anything else?
I have nothing else.
I don't.
Okay.
Thank
All
you.
right.
Thank you very
Thank you.
much.
Thank you.
Appreciate it.
If I had known it would have been just me at the end, I would have brought lunch or something.
Yeah. Thanks. Well, the matter